A black federal prosecutor stood to protect a defendant and was mocked in open court for his accent. The judge, used to control and condescension, turned the moment into a public joke. But Marcus Reed had come prepared, with calm, with truth, and with the full weight of the Department of Justice. And just wait until you see how the courtroom shifted and how justice, in the end, spoke louder than pride. It was just past 10:30 a.m. in courtroom 4B of the Jefferson County Courthouse, and Judge Harold Whitman was already growing impatient. The morning docket was packed, a stream of low-level arraignments, custody hearings, and plea conferences, and the judge, a man who prided himself on running a tight ship, was clearly more concerned with keeping the calendar moving than examining anything too closely. The courtroom buzzed with a low hum of routine exhaustion. Overworked attorneys flipping through manila folders, defendants shifting nervously in their seats, the bailiff sipping cold coffee behind a stiff posture. It was a space where people's lives turned, but where familiarity often numbed empathy. And then it happened. One of those moments that doesn't arrive with fanfare, but cuts through a room like glass falling on tile. From the back row of the gallery, a tall black man in a neatly pressed navy suit stood up. His presence was calm, composed, intentional, but also marked by a subtle edge of urgency. He spoke clearly, with a faint southern lilt that softened his vowels but not his authority. "Your Honor," he said, respectful but firm, "may I be heard on a procedural matter before you proceed?" The room quieted, just slightly, just enough for heads to tilt. Judge Whitman didn't glance up. Instead, he raised one dismissive hand, palm facing out like a crossing guard halting traffic, and let out a dry chuckle, the kind meant to signal to the room who was in control. And then, in a voice loud enough to draw attention, he repeated the man's words, exaggerating the accent with theatrical flourish. "My, I be heerd on a procedural matter." It was said with a smirk, not the kind born of humor, but of hierarchy. A few scattered chuckles followed. A sheriff's deputy near the wall didn't bother to hide his grin. Someone near the jury box snorted quietly into their sleeve. Even the court reporter paused, fingers hovering above the keys for just a second, unsure whether what had just been said should be written down or swallowed whole by the silence. The man didn't flinch. He didn't smile. He didn't bristle. He simply let the air settle, then replied, slowly and with calm authority, "Counselor Marcus Reed, it pertains to case 17-CR-451, Your Honor." His tone didn't rise, his posture didn't change, but his name hit the air like a stone in still water, not a request, but a reminder. Judge Whitman finally looked up. For the briefest moment, he studied Reed's face, as if calculating whether he'd misjudged something or someone. But the moment passed quickly, swept away by the judge's need to assert control. He leaned back in his chair, one brow lifted. "We'll get to your matter," he said, drawing out the word as though tasting something foreign and bitter. Then came the punch. "Once we finish with the real lawyers." The word hung in the room like smoke. Real. Not shouted, not underlined, but dropped like a gavel, clean and cold. No one laughed this time. Reed didn't speak again. He didn't need to. He simply returned to his seat, slow and unbothered, placing a single folder beside him. The posture of someone who understood exactly where he stood and exactly how temporary this performance would prove to be. Around him, the room shifted, subtle but real. A public defender furrowed her brow. A young law clerk looked up from her laptop. A woman in the gallery muttered something under her breath and shook her head. They didn't know who Marcus Reed was, not yet. But the tone of the moment had changed. Something had cracked, not loudly, just enough for the light to begin creeping in. What Judge Whitman had intended as a joke was about to become the beginning of his greatest professional miscalculation. Public Defender Valerie Knox sat rigid in the last row of courtroom 4B, arms crossed tightly across her chest, the tension in her jaw pulsing with restraint. She'd heard 1,000 backhanded comments in courtrooms across the county, Some dressed up as legal skepticism, others cloaked in fake humor. But this was something colder. Next to her, an older woman in a dove-gray church hat pressed a balled-up tissue to her lips. She wasn't involved in the case, just a grandmother maybe, or a neighbor, someone who'd come to support a loved one and now sat shrinking into her coat, eyes wide with disbelief. The sting of what she just heard was still hanging in the air, sharp and unmoving. Disgust moved through the courtroom like a slow leak, invisible but unmistakable once noticed. People didn't speak, they shifted, they stiffened, they avoided eye contact, not because they were confused, but because they understood exactly what had just happened, and also understood that no one was going to name it out loud. This wasn't the first time Judge Whitman had said something inappropriate. It wasn't even the 10th. Everyone in this building knew his reputation. He was old school. That was the word they used when they didn't want to call something worse. He prided himself on being efficient, a man who cleared cases like a factory clears boxes off a conveyor belt. New clerks were told, half-jokingly, that if they slowed him down, they'd be reassigned to traffic court. "He keeps the cattle moving," they'd say in the elevators. It was meant as a compliment. Whitman didn't see himself as cruel. He wasn't cartoonishly malicious. He didn't slam gavels for sport or shout lawyers out of the room. No, he thought he was saving the system. In his mind, every moment spent on emotion or nuance was a moment stolen from justice. One more day of delay meant one more person sitting in a cell, one more victim waiting for resolution, one more box unchecked on a docket that never stopped growing. But that mindset, that need to manage justice instead of deliver it, came with consequences. Over time, his shortcuts became policy. His sarcasm turned into a leadership style. And eventually, what had started as control quietly evolved into performance. The robe became a stage costume, the courtroom an audience. He didn't see Marcus Reed, not really. He saw an interruption, a speed bump, a voice with an accent that didn't match the scripts he expected in his courtroom. And rather than question his assumptions, he turned that discomfort into mockery, one that drew laughter from people who should have known better, and silence from those too tired or afraid to speak. But Reed? He'd been here before. Not in this courtroom maybe, not with this judge, but in 1,000 other rooms that looked just like it. He didn't fumble or flinch. His suit was pressed, his presence steady, his voice tempered with the quiet weight of someone who'd long ago learned that being right isn't always enough. You also have to be strategic. He didn't rise to the bait. He let the room speak for itself, and once it did, he sat back down. He opened his briefcase, pulled out a manila folder, nothing flashy, slid it across to the deputy with a calm nod. No explanation, just intention. The deputy, a man who only moments earlier had chuckled at the judge's impression, glanced at the folder as if it had burned his fingers. Something shifted in his posture, not shame exactly, but uncertainty, a realization that maybe the moment had gotten away from them. He carried the folder to the clerk, who paused in her typing to read the sticky note clipped to the top. Her eyes flicked up toward Reed, then back down. She didn't say a word, but her hands moved faster. She opened the folder, scanned the contents, and immediately handed it to the bailiff with a whispered word. Valerie Knox watched the quiet chain reaction unfold. She didn't smile, she didn't move, but deep in her chest something turned. A sliver of hope. Maybe this time the room wouldn't move on. Maybe this time someone who wasn't supposed to be overlooked would finally be impossible to ignore. And Whitman, still oblivious to what he had just set in motion, turned back to the docket with the confidence of a man who believed the page always belonged to him. But the chapter was already changing. Case number 17-CR451 was called with the sterile efficiency of a lunch counter number. In the second row, Tyrone Wells stood slowly, as if every joint carried the weight of a man much older than his 32 years. He was tall but gaunt, his suit slightly too big, his cuffs frayed from being worn too often and washed too hard. There was no lawyer beside him, just him, alone under fluorescent lights, facing a charge that might have seemed routine on the surface, but hid something far more dangerous underneath. A state fraud charge. Paperwork, they'd say. Plead it out, they'd urge. Save time, clear space. But this wasn't about paperwork. This was about leverage and survival. What most people in the courtroom didn't know was that Tyrone's name appeared on a sealed list tied to an ongoing federal investigation, a complex, high-stakes case crossing 3 states and involving multiple defendants. If Tyrone entered a plea in state court that day, he could unintentionally waive key protections, destroy any chance of a cooperation agreement, and worst of all, put a target on his back once federal charges started to roll out. It wasn't just a legal misstep, it was a setup for catastrophe. And Marcus Reed knew it. He stepped forward to the rail, calm but deliberate. His voice was measured, not loud, but layered with purpose. "Your Honor," he began, "I'm requesting 5 minutes under People v. Hargrave to address federal custody coordination and detainer implications before any plea is entered. The court has been." But Judge Whitman didn't let him finish. He cut across the sentence like a blade. "Sir," he snapped, voice sharp and dismissive, "I don't know who sent you, but you're not going to hijack my courtroom with theater." Then he turned slightly toward the gallery, inviting them into the performance. His next words were slower, crafted for impact. "If you'd like to audition, the community theater is on Maple Street." A few half-hearted chuckles stirred in the gallery, but even those felt forced, nervous, unsure. The room was shifting again. Some people still thought it was all part of the usual courtroom banter. Others were beginning to feel it, the unmistakable crackle of something deeper, something dangerous building just beneath the surface. Marcus Reed felt the heat rise in his face, not from embarrassment, but from fury. Not at the insult, he'd been insulted before. Not at the mockery, he'd weathered worse. But because Tyrone Wells, a man who had trusted the law enough to cooperate, was being treated like a footnote in a performance. Because a judge who was sworn to uphold justice had just made a joke out of a man's freedom, his safety, his future. Every cell in Reed's body wanted to react. He could have raised his voice, flashed his badge, let the room know exactly who he was. He could have unleashed years of frustration with the weight of his title behind every syllable. But he didn't, because Marcus Reed understood something Whitman didn't. This wasn't just about pride. This was about protection. So, instead of matching fire with fire, he exhaled, slow, controlled. Let the words fall cleanly, without decoration. "Then let's proceed on the record." No threats, no raised tone, just a quiet shift, like a storm that chooses not to strike, but instead rolls closer. He turned to the clerk with a slight nod. The clerk, who had heard the tension, had seen the folder, had felt the gravity beneath Reed's silence, hesitated, then opened the manila envelope. Her hands moved more carefully this time. She read the short cover memo stapled to the top, then looked up. Her lips parted slightly. No more jokes now. She began to read aloud, slowly for the record. "A formal request from the United States Department of Justice, Eastern District, regarding coordination prior to plea entry in Case 17-CR451, due to an active federal investigation involving the defendant." The words United States Department of Justice landed like cold steel on the room. A ripple moved through the courtroom. The laughter stopped. The air tightened. The seal on the letter wasn't a prop, and Marcus Reed wasn't a spectator. Now, suddenly, people were paying attention. Valerie Knox, still seated in the gallery, leaned forward slightly. The grandmother with the tissue sat up straighter. Even the deputy who had smiled earlier stiffened as he folded his arms.
The realization moved like a slow quake. This wasn't theater. This was federal law. And Judge Whitman, still seated, still gripping the bench like it gave him power, was beginning to understand that he might have made a mistake. Not just in tone, not just in attitude, but in assuming that the man with the accent, the man he mocked, was beneath his courtroom. He was about to learn just how wrong he'd been. And Marcus Reed, who could have burned the room down with a sentence, had chosen instead to let the truth do the burning for him.
Judge Harold Whitman had been on the bench for over 2 decades. In that time, he'd seen defendants sob, lie, break down, lash out. He'd seen prosecutors stumble, attorneys bluff, families fall apart. And in all those years, one thing had kept him rooted, the belief that he could read a room in seconds, that his instincts, sharpened by repetition and authority, were rarely wrong. But now, standing across from a man he had mocked not 5 minutes earlier, he felt something unfamiliar, uncertainty. For a moment, he tried to hold his posture, tried to remain the center of gravity in the room, but his voice betrayed him. Quieter now, a note higher than usual, as he asked, "And who exactly are you?" Marcus Reed didn't blink, didn't lift his chin, didn't change his tone. He reached into the inside pocket of his blazer, pulled out a simple white card, and placed it gently on the wooden bench like a checkmate in slow motion. "Marcus D. Reed," he said evenly. "Assistant United States Attorney, Eastern District." He said it plainly, not as a boast, not as a threat, simply as a fact that carried the weight of its own truth. The silence that followed was total. Not awkward, not uncertain, final. It swept across the room like a cold front. The deputy who had laughed earlier now stared fixedly at the scuffed floor tiles, his smirk long gone. The court reporter, who had paused her typing during the exchange, now clacked away at full speed, fingers urgent, shoulders stiff, capturing every syllable as if it might someday be evidence. From the gallery, Valerie Knox didn't speak, didn't smile. She simply closed her eyes for a breath, long, slow, not relief exactly, but release, a breath she hadn't known she'd been holding. And Whitman? He didn't say a word. But something in his face, something around the eyes, gave way. For the first time that morning, he truly looked at Reed. Not at the suit, not at the accent, not at the perceived intrusion, but at the man, the authority, standing before him. And he understood what he had done. Not just the words, the message behind them. He tried to diminish someone carrying the weight of federal responsibility. He'd made a punchline out of a professional, one who had come into his courtroom not for ego, not for drama, but to protect a man whose life was about to be irreversibly altered by a premature plea. And Reed, with complete composure, began to speak again. No anger, no victory in his tone, just precision. He laid out the facts with surgical clarity. The existence of a federal detainer tied to a sealed multi-jurisdictional indictment. The risk of violating coordination protocols between agencies. The very real threat of double jeopardy exposure if Tyrone pled that morning. He referenced People versus Hargrave, United States versus Lane, Rule 20 of the Federal Rules of Criminal Procedure. Then, almost as an aside, he mentioned 2 sealed federal cooperators from previous cases. Both of them had rushed pleas in state court. Both had been exposed. Both had received threats within weeks. The implications hung in the air. Then Reed said, in a voice that neither scolded nor preached, "Justice is timing, Your Honor. If we rush, we break it." That was it. No crescendo, no dramatic pause, just the raw center of his argument and of his profession. Because this wasn't about courtroom theater or judicial pride. This was about a man named Tyrone Wells who sat trembling in the defendant's seat, unaware of how close he'd just come to forfeiting not just his rights, but possibly his safety. Whitman shifted in his chair.
The robe that had once felt like armor now felt heavy, like wool in summer. A costume he wasn't sure he deserved at that moment. In his mind, Whitman wasn't the villain. He never saw himself that way. He was a man of rules, of order, of clean dockets and efficient calendars. He told himself that his courtroom worked because he kept it moving, because he didn't let nonsense get in the way of justice. But for the first time in a long while, he heard something beneath the polished cadence of a prosecutor's voice. Duty. Not to the clock, not to his image, but to the people who walk into that room, trusting, sometimes desperately, that the law will see them. He looked around and saw a room that had turned, not because Reed had shouted, not because anyone had rebelled, but because Reed had done what Whitman had forgotten. He had listened first. He had understood fully, and then he had spoken, not for himself, but for someone who couldn't afford to be ignored. It wasn't rage that shook the courtroom. It was clarity.
The room had grown still, not silent, but quieter in a different way. Like after a storm has passed and no one speaks, not out of fear, but out of reflection. Something had shifted in courtroom 4B. The air was no longer thick with tension. It was heavy with recognition. Judge Harold Whitman adjusted the microphone, slowly, deliberately. The same mic he had used not half an hour earlier to deliver a punchline at someone else's expense. But now he leaned into it differently, not to perform, not to control, but to take responsibility. His voice was quieter than usual, not unsure, but not performative either. "Counselor Reed," he said, his tone stripped of any pretense, "you'll be heard." He didn't look to the gallery for approval this time. He didn't ask for the moment to be softened or forgotten. He simply turned to the courtroom as a man who had realized, too late perhaps, that the room had been watching all along. "The court regrets its earlier remarks," he said, his eyes not quite meeting Reed's. They were inappropriate. There was no applause, no dramatic silence, just the sound of a courtroom correcting itself, one sentence at a time. Marcus Reed nodded once, nothing more. He didn't posture. He didn't offer absolution. What he had come for was never personal. It was procedural. It was protective. He was here to shield a man from legal harm, not collect apologies. With permission now granted, Reed stepped forward and began to argue, clearly, precisely, for a continuance in Tyrone Wells' case. He laid out the legal basis, the risk of conflicting jurisdictions, the potential violation of due process, and the documented threats to past federal cooperators who had pled too soon in state court. He cited statutes and procedural memos like a surgeon wielding tools, efficient, exact, and without ego. From the gallery, Valerie Knox rose and co-signed the request on behalf of the defense. Her voice, firm and steady, carried the weight of solidarity without needing to explain it. On the other side of the aisle, the state prosecutor, visibly flushed, his fingers fumbling slightly with his notes, stipulated without protest. Tyrone Wells, who had said almost nothing all morning, exhaled. Visibly, his shoulders dropped as if someone had taken a backpack of bricks off his back. He sat down slowly, hands still trembling slightly, and let out the kind of breath that only comes after months of holding one in. Judge Whitman granted the continuance, but he didn't stop there. Without prompting, he turned back to the clerk. "On the court's own motion," he said, "a minute order shall be entered into the record." And then, calmly, he laid out the following. A formal reminder to all courtroom personnel, counsel and staff alike, regarding standards of professional conduct and respect. A requirement for bias and decorum training for his courtroom team, effective immediately. And finally, a written apology from the court itself to be included in the case file of 17-CR451. It wasn't a press release. It wasn't damage control. It wasn't reputation management. It was a man trying, quietly, to make a repair, not to his image,
but to the integrity of the bench he sat on. Because for all his years on the bench, Judge Harold Whitman knew something too many forget. A robe doesn't make you right. It only gives you reach. And if the reach can't admit a mistake, it has no place in a system that claims to serve justice. The courtroom began to empty slowly. People collected their bags, checked their phones, whispered into each other's ears with subtle glances back toward the bench. But Marcus Reed remained near the railing, packing his briefcase carefully. Not rushing, not lingering, just completing the task he came to do. As he turned to leave, Judge Whitman called out, softer now, with a voice that didn't demand, only asked, "Mr. Reed, thank you for your patience." Reed paused. He met the judge's eyes, not coldly, not cruelly, but with the kind of calm that can't be shaken by power. "Patience isn't the point, Your Honor," he said, voice steady. "Protection is. No more, no less." He walked out of courtroom 4B without raising his voice, without demanding a spotlight, and without waiting for anyone to praise him. That wasn't why he was there. And yet, his presence lingered. Word of what had happened traveled down the courthouse halls in soft, certain ripples, not as gossip, not as scandal, but as example. People didn't retell the judge's joke. That part faded quickly, like smoke. They retold the correction. They retold the composure. They retold the way a man, disrespected in public, chose precision over pride, and forced a courtroom to remember why the law exists at all. And in a place where the docket usually churned like a conveyor belt, one case after another, faces and names and lives passed through like paperwork. One case had made the system stop, just for a moment. It had stepped off the belt, planted its feet, and waited for justice to catch up. That was the victory. Not one that trends, not one that shouts, but the kind that changes the temperature of a room, the kind that reminds a judge what the gavel is for.